Welcome everyone to the webinar, New Year, New Rules, Impact of the New Tax Bill on Employee Benefits. We are Hall Benefits Law. I'm David Hall, the firm manager here, and I had a couple of housekeeping items I'd like to share with everyone before we get started. If you are an attorney in attendance, please email your name and your bar number to admin@hallbenefitslaw.com so that we can process your CLE. Time permitting, we will be answering questions at the end of our presentation. Please type your questions into the GoToWebinar question field. If you have any questions about that, please go to the GoToWebinar website and you should be able to find their FAQs about how to ask questions during webinar. We will also be sharing this webinar recording with all of you by email. Please do us a huge favor and share that recording within your own organization and on social media. That's how people learn about Hall Benefits Law. And finally, there will be a brief survey at the conclusion of the webinar. I believe it's 4 or 5 questions, and your answers help us to make these webinars the best that they can be. With that said, I'd like to go ahead and officially get the webinar started by telling everyone here a little bit about who we are and let you meet some of our team who will be speaking to you today. So Hall Benefits Law is an ERISA and employee benefits law firm. We offer employers comprehensive legal guidance on benefits in mergers and acquisitions, employee stock ownership plans, executive compensation, health and welfare benefits, healthcare reform, retirement plans, and tax controversy and business planning. Our mission is to provide comprehensive, personalized, and practical ERISA and benefits legal solutions that exceed our clients' expectations. Today, you'll be hearing from Ann Tyler Hall, who is our owner and principal attorney. Prior to forming the firm, Ann Tyler practiced ERISA and benefits law with Alston & Bird and King & Spalding, two of Atlanta's largest law firms. She has been named a 2017 and 2018 Super Lawyers Rising Star, and she maintains a Martindale-Hubbell rating of preeminent, which does represent the highest achievement of professional excellence based upon both client and peer review. She has her Master of Laws in Taxation with distinction from Georgetown University Law Center, and she has her JD from the University of Alabama School of Law. Also joining us today will be Leah Singleton. She is the firm's Director of Legal Operations, formerly counsel at Alston & Bird LLP's Employee Benefits and Executive Compensation Practice Group. She also practiced employee benefits at McKenna Long and Aldridge and Troutman Sanders. Leah uses a practical and business-focused approach to advise her clients on complex employee benefits matters, drawing on prior experience both as a compliance consultant at a large human resources consulting firm and a former small business owner herself. She focuses her practice on on advising corporate, not-for-profit, governmental, and individual clients in all matters relating to employee benefit plans and executive compensation at every phase. The newest team member to our senior legal team is Deborah Andrews. She is our senior compliance counsel. She is also a CPA. Her practice encompasses a broad range of complex tax matters. She regularly advises individuals, businesses, and tax-exempt entities on various issues related to transactional matters, tax planning, executive compensation, employee benefits, and tax reporting. In addition, she represents clients in handling tax controversies with federal and state taxing authorities. Deborah also has her LLM in taxation from Georgetown University Law Center. So if you need those names, there they are. Ann Tyler Hall, Principal Attorney, Leah Singleton, Director of Legal Operations, and Deborah Andrews, Senior Compliance Counsel. So here's a brief discussion outline. We'll be covering today the overview of the new tax bill, implications for employee benefits, including health and welfare benefits, retirement plans, and executive compensation, an overview of corporate and individual tax law changes, including C Corp and individual tax revisions, small business and pass-through entity tax changes, and what are those implications to benefits? And again, time permitting, we will have a session of question and answer. With that, I will be passing the mic to Ann Tyler Hall.
Thank you, David. Well, we're excited to be here today and talking about the changes under the 2017 tax bill or new tax bill. There is a lot to talk about. The bill is dense, and so we're going to try to cover as much as we can related to benefits and some corporate structural entity changes potentially on the horizon if you're looking to maximize the changes under the new tax bill. Before we dive into the new tax bill, just a little bit about our firm and what we do and what we focus on: ERISA legal compliance. And we stress being proactive and preventive because we deal every day after an ERISA legal compliance problem has already happened or an audit has happened and our client is in a penalty situation. So part of the reason it's so important to be aware and apprised of the changes under the tax bill is that our clients' plan sponsors, the service providers who work with them, we want to be aware of these changes so we don't run afoul of the rules. General overview of the governmental jurisdiction over benefit plans and the executive compensation programs and ESOPs that we work with: Department of Labor, Department of Health and Human Services, the IRS, and more participants and plaintiffs' attorneys are becoming savvy about ERISA legal compliance requirements. There's been a perception over the past year that enforcement has not been as active. And I think that these statistics indicate that that's not true. Department of Labor releases their statistics each year about their audits and about the recoveries for benefit plans. And you'll see for the past 3 years, and in 2017, 1.1 billion in recoveries, which means that a lot of these recoveries are the result of audits and enforcement actions against plan sponsors. And so this is what we want to keep plan sponsors out of. We do not have statistics for the IRS and the HHS, but we know that the Department of Labor alone has increased its audit action. And just to note that there have been, over the past year, unfortunately, criminal investigations, indictment of 113 persons for crimes related to employee benefit plans. Of course, we want our clients not to ever be in this situation. But again, this highlights why ERISA legal compliance is so important. And the Department of Labor alone has been very active over the past year. Just want to make another note. Last year alone, benefits advisors with the Department of Labor closed more than 174,000 inquiries. This is the Department of Labor gets a call from a participant that says something's going wrong with my benefit plan, with our employer benefit plan. So that highlights again why it's so important to be aware of these changes. Okay, so jumping into the new tax bill, a little bit of background. Final Tax Cuts and Jobs Act originally passed the House on December 19th, but actually due to a procedural issue was voted on again and passed on December 20th. Similarly, the Senate voted and passed the bill on December 20th, and then President Trump signed it 2 days later. Two notes to make before we launch into some of the changes in the new tax bill. Firstly, there are many opportunities for benefit plan design, and corporate structure design opportunities through this new tax bill. And we are here to help navigate those changes and think about those changes as it relates to your specific company and situation. Second issue to think about as we're walking through these slides is there are many different effective dates for these changes. Many of the changes are effective beginning in 2018 and sunset or expire beginning in 2026, but not all of them. And so we will try to make clear to you the effective date of the changes of each of these changes under the tax bill that we're going to cover today. So jumping in, health and welfare benefits. Biggest change there was essentially an effective repeal of the individual mandate penalty. Now, this effective repeal does not take place this year. So that's the big issue here is just being mindful that this change takes effect beginning in 2019. For 2018, the penalty is still the greater of, it's a monthly penalty, but the greater of a 12th of 2.5% of the taxpayer's household income, or $695. Beginning in 2019, the tax bill essentially went into this provision in the code and reduced this penalty to $0. What do we think the impact to healthcare reform of this change under the new tax bill will be? Well, essentially, ACA is still the law of the land. What does that mean for our employer clients? Employer pay or play penalty still intact. We had a client that we worked with over the past few months that was assessed a 2015 employer shared responsibility payment assessment of over 6 figures. So the IRS is still active and in enforcing the pay or play penalty, and it is still the law of the land. Just a note that the penalty amounts have gone up since originally in force in 2014. They've gone up a total of about 16%. And the affordability safe harbor for 2018 is 9.56%. So the change of the new tax bill just to the individual mandate penalty, not to the employer pay or play penalty. What are some practical implications? We may see fewer health plan enrollees in our health plan, employer health plans, because they're not going to be subject to a penalty beginning in 2019. For this year, not likely to see a whole lot of change. But just a reminder that the employer penalties remain. So if you're an applicable large employer, you are still subject to the employer pay or play penalty if you do not offer ACA compliant health coverage. Before we launch into the qualified bicycle reimbursement, just wanted to note that employers may no longer deduct qualified transportation fringe benefits, including for the provision of transportation via commuter highway vehicle, transit passes, and qualified parking. So the new tax bill took away the deduction for many of the qualified transportation fringe benefits. However, employers may continue to deduct qualified bicycle reimbursement expenses. Unfortunately for employees may not deduct these reimbursements, these qualified bicycle reimbursements. A note to make is that qualified bicycle reimbursements will no longer be deductible by employers beginning in 2026, but still deductible for employers for 2018 through 2025. Qualified moving expense deduction, a big change here. So if you are an employee and you incur qualified moving expenses as defined in Code Section 217, prior to the new tax law, you could deduct if the employer reimbursed you for those expenses. So for instance, an employee incurs $3,000 of qualified moving expenses, and the employer reimburses that employee prior to the new tax law, that would not be includable in income. After 2017, now under the new tax bill, those amounts are no longer deductible. Similarly, if you incur qualified moving expenses and you are not reimbursed by your employer, previously those would be deductible as an itemized expense. After the tax bill, those are no longer deductible. This is effective beginning in 2018 through 2025. Note that there is an exception and essentially no change to the qualified moving expense deduction for members of the U.S. Armed Forces on active duty who move pursuant to a military order. So a big change there. Before we get into the changes to retirement plans, I also wanted to note big change here to employers can no longer deduct entertainment, amusement, recreation expenses. This has been a big deduction for employers prior to the new tax bill. And previously, employers could deduct 50% of the cost for entertainment, amusement, recreation expenses related to employees, and then membership dues for clubs organized for businesses. That goes away with the new tax bill unless there is an exception to that. There's an exception if the employer includes the value of the expenses related to the entertainment, amusement, recreation expenses in an employee's income then they may deduct the 50% of the cost of these expenses. This change is effective beginning in 2018, no sunset to this change. So now we're going to look at, we talked about some of the health and welfare benefits changes, and just another note, a couple of other changes to mention. There is a change now to the cost of living adjustment, the index used for cost of living adjustments to health FSAs, HSAs, the Cadillac tax. Prior to the new tax bill, prior to the 2017 tax bill, we were using a CPI-U index for inflation. We will now be using a chained CPI-U, which essentially is a slower inflation rate. So for health FSAs, HSAs, this also applies to retirement plans. We've got a new indexing for inflation adjustments to retirement plans and health and welfare benefits. This change appears to begin immediately, effective for the 2018, and this is a permanent change. One other health and welfare benefits change wanted to mention is the deduction for medical expenses. Previously, individuals could deduct medical expenses that exceed 10% of adjusted gross income. That has been lowered, and this is effective for the 2017-2018 year only. But medical expense deduction reduced from 10% to 7.5%. So if your medical expenses exceed 7.5% of your adjusted gross income, they are deductible amounts in excess of 7.5% of adjusted gross income. Okay, retirement plan changes. So beginning this year, if you terminate employment with an employer, or if your employer retirement plan terminates, previously, if you had a loan under that plan, you had 60 days to repay the loan, or it was a deemed distribution. New tax bill lengthens the time period in which you can repay that loan. So you have generally until the due date for your tax return, including extensions, and you are permitted, as an employee, you are permitted to contribute the loan balance to an IRA or to simply just repay the loan. We recommend that you engage counsel to review your plan's loan policy and accommodate these changes in your plan documents to reflect the changes under the new tax bill. Another retirement plan change is beginning this year, effective for this year, is that if you have made a contribution during the year to, for instance, a traditional IRA, and you recharacterize it to a Roth IRA, under the prior law, you could then decide in the ensuing year whether you wanted to keep it as a Roth IRA recharacterization and then convert it back to a pre-tax or traditional IRA if you so desired after looking at the tax implications. You can no longer unwind that conversion after the end of the year. You could still, during the tax year, so for 2018, if you make a contribution to a traditional IRA, you can, during the tax year, decide that you want to recharacterize that to a Roth IRA. You cannot, after 2018, though, then roll it back or reconvert it to a traditional IRA. So that's another significant change on the retirement plan side. Final change that we're going to talk about today on the health and welfare benefits retirement plan changes relates to 529 plans. Now, traditionally, 529 plans have been reserved for expenses, qualified expenses related to college. And so 529 withdrawals are tax-free, have been tax-free in the past, as long as the funds were spent towards qualified higher education, so post-secondary education expenses, including tuition, room and board, computer software and equipment, but generally solely exclusive for post-secondary education expenses. New tax bill expands the use of 529 plans. So now you can use your 529 savings for private elementary and secondary school expenses. It doesn't matter whether the schooling is public, private, religious. The tax-free treatment will apply, but it will be limited to $10,000 per student per year for pre-secondary education expenses. One of the practical implications with this is that generally in a 529 plan, you start it when your child is young, and the idea is that those contributions grow tax-free. So we may see in 529 plans that those accounts don't grow as large as they had been when the expenses were limited to post-secondary expenses only. But this is an expansion of the 529 plan. With that, I am going to turn it over to Leah Singleton.
Okay, so the Tax Reform Act had some impacts to executive compensation. And when we talk about executive compensation, we think about plans and programs that are only available to either an individual or to a select group of people. They're typically not available to the whole population at large, hence the name executive compensation. So there were three main changes to the executive compensation world under the Tax Reform Act. And the first one is what a public company, or how much a public company can deduct for paying executives' wages. And there's been in existence $1 million deduction limit that's under 162M of the Internal Revenue Code. You may hear 162M referred to quite a bit. It was a complicated code section and analysis, and it had a lot of differentiation about what types of employees were covered by the rule, what types of compensation are subject to the deduction limit. Some other types of compensation was not subject to the deduction limits. And so us benefit attorneys spent quite a bit of time trying to structure executive compensation in a way to maximize an employer's deduction under this rule. So after tax reform, the Act actually strengthens the restriction on the deductions allowed for public company executive pay. In other words, the effect is a very hard cap on deductible compensation of $1 million. And this will apply to a larger group than it did before. So in the past, you could pay some performance-based compensation and commissions and not be subject to this limit, and the new tax reform bill took that away. All of that money is now subject to the limits. In the past, the employees that were subject to this deduction limit were mainly the CEO, the CFO, and the three other most highly compensated officers during the tax year. This rule expanded it to include the CFO and anybody who acts as a CFO, even if that's not their title. And it also expanded it to be any person who had those job descriptions at any time during the tax year, instead of just looking at the last day of the tax year that we used to do before tax reform came about this year. The other requirement that it continues to cover employees, even after they're terminated or even after they're not considered covered under this rule, as long as they're still receiving compensation from the company. So even after they're terminated from employment, this new rule could continue to apply to them. And this new rule also expands the definition of what a public company is to include public companies and those also with registered debt securities, or private companies with just a large number of equity holders. So in effect, this is going to include a lot more foreign companies than have ever been included before. All these changes apply now in 2018. There is a transitional rule, though. The new rules do not apply to compensation paid under a written, and written is very important, binding contract that was in effect on November 2nd, 2017, provided that contract is not modified or renewed after that date. So there's lots of rules about what is a written binding contract and what is amending or modifying it after that date and what that means. So what does this mean to public companies now? Well, basically the deduction is a lot stronger deduction than it ever has been before. And it means that you need to review your compensation committee composition, your performance goals that you used to use for this performance-based compensation because you needed that to be excluded from this deduction limit. That is kind of moot now. So you want to look at performance goals, exclusions, establishment of performance goals to see if that's even needed anymore, and the preserving grandfathered arrangements and even shareholder approval. So there's lots to be done in this arena for 162M for public companies. The next big change had to do with paying executive compensation by tax-exempt organizations. So in the past, tax-exempt organizations had no excise tax when it came to paying executives the compensation. Under this new tax reform, they're subject to a 21% excise tax when they pay a covered employee more than $1 million. Or amounts in excess of 3 times their base amount is paid upon separation from service. And that's really the traditional golden parachute rule that has applied to regular for-profit companies, and they've just expanded it to tax-exempt organizations. What's interesting about this is that wages are defined very broadly to include all wages paid to the employee during the year. It also includes wages that are paid from related entities, although we're still unclear who's going to be, if there's more than one entity involved in paying more than $1 million, which entity has to pay the 21 excess tax or how to prorate that. So we need a lot more guidance about that at this point. The Tax Reform Act also says that compensation is paid when it's no longer subject to a substantial risk of forfeiture, even if the executive didn't receive the money in their hands. So there's a lot of analysis to be done here. What can be exempt from the 21% excise tax? Well, payments to licensed medical professionals and veterinarian services. So that was an interesting exclusion. And compensation that is remains subject to a substantial risk of forfeiture, or compensation that's not vested, such as a SERP or an LTIP or bona fide non-competes and some type of elective deferrals. So there is a lot of planning opportunities here for tax-exempt organizations so to plan how to structure an executive's compensation in excess of $1 million so that the organization doesn't have to pay the 21% excise tax. We're only just beginning to fully process these changes. There's a lot of unanswered questions. We need some more guidance that will be coming down the pipeline here, but there's still a lot of opportunity to mitigate the bite of this new excise tax. Okay, the third type of major change that occurred under this Tax Reform Act was these qualified equity grants. So these are equity grants by private companies. So the Tax Reform Act created a whole new section of the tax code that delays for up to 5 years the taxation of compensation that is paid to employees in the form of qualified stock. Now, there's a lot of twists and turns in this new code section and a lot of different requirements that have to be met. But if those requirements are met, there's a huge advantage here to defer the taxation for the employees, and it also helps with the deduction for the employer as well. So this provision does not apply to all forms of equity compensation, and it only affects private companies with very broad-based programs, and we're going to talk about that in a minute. The main advantage of this is one, the employee gets to defer the taxes up to 5 years. The second is it converts the payment to long-term capital gain. There's a little bit of a complicated calculation. So a portion may be long-term capital gain and a portion may be income, but there's still some long-term gain, long-term capital gain opportunities there. And one of the big things for us benefit professionals is if you meet the requirements of this code section, the stock is not treated as deferred compensation for purposes of code section 409A, which is a huge advantage in being able to amend stocks and defer and do different things with the payment. So what do we have to do to get this? Well, one thing is the employees have to make an affirmative election within 30 days of receiving an equity grant. Once the grant is made, the stock is generally taxed on the date that is 5 years after it vests. Now, there's some different things that may come into effect if the employee revokes a deferral election or if the employer buys back the stock, but generally it's a 5-year rule. The 83I election is not available to 1% owners, CEOs, CFOs, spouse, child, grandchild of any of those people. One of the 4 highest paid compensated officers for the past 10 years, and it's not available to independent contractors. The other thing about this, it's only available to a certain eligible corporations. And to be eligible to offer this type of plan, you have to have stock that is private. It's not readily tradable on a securities market. And it has to be offered to 80% of all of your employees. And this is really what I think might get some private companies so that they are not able to offer this, because most companies who offer equity grants don't offer it to 80% of their employee population. They usually only offer it to management and a select group of employees. But to qualify for these tax advantages, it has to be offered to 80% of the full-time employees. And it has to be offered in the form of stock options or restricted stock units. And employees have to receive more than a de minimis amount in order to qualify for this. I think that most employers, especially of private companies, tend to like synthetic equity instead of offering real equity. And so while this has a lot of tax advantages to it, may not have all of the practical implications that we hope for, but it is still an excellent. It's good news. Private companies can definitely take advantage for this. While there's a lot of stringent requirements for it, I think employers should definitely consider this when they're looking at whether to offer equity and to incentivize employees, because it could make the company's equity program more attractive, could help incentivize, could help recruit employees. And I think private companies may be able to take a lot of advantage of this depending on the stability of their stock price and the possibility of a liquidity event for the stock in the future, just because of the conversion to the long-term capital gains treatment. So with that, I'm going to turn it over to my colleague, Deborah, who's going to give us a summary of the corporate and individual tax changes. Deborah is an attorney, but she's also a CPA and has a master's of tax from Georgetown, and is a great resource for us and our corporate clients with her tax background. So Deborah.
Thank you, Lee. And I just want to say it's great being a part of the Hall Benefits team. Let's see. All right, for most taxpayers, their tax rates were reduced in 2018. C Corps now have a tax, they're now taxed at a flat rate of 21% instead of graduated rates that applied previously, which range from 15 to 35%. Individual tax rates have been reduced from a top rate of 39.6% to 37%. There was also a change made to the alternative minimum tax, or AMT. Now, AMT is a second tax system that is applicable to corporations and individual taxpayers. And the purpose of AMT is to reduce a taxpayer's ability to use certain tax deductions or other benefits in order to avoid tax. Well, the calculation of AMT can be extremely complicated, and in an effort to simplify the rules, the AMT was repealed for C corporations. And although the AMT was not repealed for individuals, the exemption was increased. So consequently, AMT should affect fewer individuals. Just want to mention that the C Corp tax rate and AMT repeal is going to be permanent, while the individual reduction in tax rates and AMT repeal is going to expire in 2025. A significant amount of businesses are flow-through businesses, meaning that the business owners actually report the business income on their individual income tax returns. So I thought it would be helpful to briefly go over some of the tax law changes that affect individuals. The standard deduction is almost double what it was previously in 2017. For joint filers, the standard deduction is now $24,000, and for single filers, it is now $12,000. Although the standard deduction has increased, personal exemptions are eliminated, and previously a taxpayer was allowed over a $4,000 deduction for themselves, their spouse, and each independent. Well, now that has been repealed. Higher income taxpayers are probably going to benefit the most from the reduction in the lower tax rates and the increased standard deduction, because these taxpayers were subject to a phase out anyway of the personal exemption and itemized deduction. So they're probably going to benefit from this. Larger families may be adversely affected by the loss of the personal exemption. However, the increase in the amount of the child tax credit may end up being a wash for them. Again, this is going to expire in 2025. There were a few common itemized deductions that had changes. The mortgage interest deduction is now going to be limited to debt up to $750,000, and deductions for home equity loans are now going to be disallowed. The deduction for state taxes, which is going to include your income taxes and your property taxes, are now going to be capped at $10,000. However, if those taxes are related to your business, then you're still going to be able to deduct that. The charitable deduction has been expanded. Taxpayers can now deduct up to 60% of their AGI if they're making a contribution to a public charity, and this is up from 50% of the AGI. I also want to mention that the PEACE limit, which was an overall limit of itemized deductions for high income taxpayers, has been suspended. Again, these changes are going to expire in 2025. Okay. One of the most significant changes under the Act is the enactment of new Code Section 199A. And under this new rule, a non-corporate taxpayer who has qualified business income from a pass-through structure, which is going to include sole proprietors, S corporations, and partnerships, may now be able to deduct 20% of their QBI. So this is going to basically result in an effective tax rate of about 29.6% on business income, which is the top individual rate of 37% times 80%. Well, what is QBI? QBI is basically income that you earn from a business that's conducted in the United States, but does not include wages that you earn as an employee or guaranteed payments that you receive as a partner. So for example, if you are an S Corp owner and you receive $50,000 in wages from the S Corporation and you're allocated $75,000 in S Corp income, then your QBI is going to be $75,000. It is not going to include the $50,000 in wages that you receive. In talking about QBI and how to calculate your deductions, I just want to mention that there are some components that I'm really not going to focus on, like cooperative dividends and rate dividends. In an effort to try to simplify the analysis, I'm just going to focus on the key features of the deduction. The QBI deduction is going to be subject to several limitations, which makes this calculation so complicated. And one limit is going to focus on specified service trade businesses. Well, these are going to be businesses that are going to include your traditional service professionals, such as your lawyers, your accountants, doctors, and any other business where the principal asset of the business is the reputation or the skill of the employee. Engineers and architects are specifically excluded under this rule. Now, the ability of an owner of a specified service business to take the deduction is really going to depend on the owner's taxable income. When I say taxable income, I mean taxable income from all sources. The owner may fully qualify for the deduction if his or her taxable income is below the threshold of $157,500 if the owner is a single filer, and $315,000 if the owner is a joint filer. Well, if the owner's taxable income is greater than $207,500, $415 if it's a joint filer, then the owner of a specified service business is going to be totally disqualified from taking a QBI deduction. I also want to mention that the determination is made for each owner. So you can have one owner that qualifies for the deduction while another owner is disqualified. It really depends on each owner's taxable income. So what about your special specified business, your specified business, in that situation, the business owner is going to fully qualify for the deduction if the owner's taxable income is no more than the $157,500, same threshold as before. However, in this situation, if the owner's taxable income is greater than the $207,500, $415 threshold, then the wage limit and property limits are going to be triggered. So under this rule in general, if the owner's income is too high, then the business is going to either have to pay wages or it's going to have to have depreciable property used in the business, because the deduction can't exceed the greater of 50% of the owner's allocable share of the wages paid, or the sum of 25% of the owner's allocable share of the wages, plus 2.5% of the unadjusted basis of the property used in the business. And there's also a cap that relates to taxable income. The deduction can't exceed 20% of the taxable income less net capital gains. All right. So what I did was try to come up with an example to try to illustrate how this deduction works. Let's assume that Al is a 50% owner of XYZ, which is an LLC, and it operates a bakery. XYZ's net income is going to be $1.6 million, and it pays wages of $400,000. The adjusted basis of the property held by XYZ is $60,000. Al and his wife have other income of $100,000, and they file a joint return with $50,000 in itemized deductions. Well, because Al is a 50% owner, his allocable share of the income from the business, or QBI, is going to be $800,000. His allocable share of the wages is going to be $200,000, which is half of the wages paid of $400,000, and his allocable share of the basis is $30,000. So how do you determine what his QBI deduction is going to be? Well, 20% of QBI, or his allocable share of QBI, is $160,000. The wage property limit, which is the greater of 50% of the wages, or 25% of the wages plus 2.5% of the basis in the property, is going to be $100,000. And then you have to perform the taxable income limit. Well, as you can see, the net business income was $800,000, but you also have to include other income that Al and his wife had, which was $100,000. So you have a total AGI of $900,000 less itemized deductions of $50,000. So $850,000 is the taxable income that Al has for purposes of the QBI. Multiply that by 20%, you're going to have a taxable income limit of $170,000. And note that because Al's taxable income was greater than the threshold, that's why the wage and property limit was triggered. Al is going to be entitled to a deduction of a lesser of those three amounts that were calculated. So Al's deduction is going to be $100,000. Just keep in mind that the QBI deduction can be a significant benefit for pass-through businesses. However, as you can see, the rules are extremely complicated, and you're really going to have to try to navigate through the limitations in order to see if you can qualify. I'm sure the IRS is going to be releasing a huge amount of guidance on this QBI deduction in the upcoming months and possibly the upcoming years. So please stay tuned. Now I'm going to hand it off to Leah to discuss how ESOPs are impacted.
So there's no direct ESOP specific language in the Tax Reform Act, but impacts the ESOPs are still impacted by a lot of the things that Deborah just talked about. So one of the ways ESOPs are going to be impacted, and ESOPs are the employee stock ownership plans. They're going to be impacted by new limitations on how much interest expense is deductible. We didn't really spend a lot of time talking about that, but there is a decrease in the interest that is deductible for businesses under the Tax Reform Act. And so for some ESOPs that are leveraged or newly leveraged, which means they have a loan to pay for the stock, and the company borrows an amount that's pretty large, their deductible expense will be lower, and therefore their taxable income is going to be higher. So ESOPs would be negatively impacted by that. Note that doesn't affect S corps that are 100% owned by the ESOP, since those entities don't pay taxes. Also, the Tax Reform Act imposed a cap of the $10,000 on the amount of state and local income taxes that can be deducted from gross income, and that included the property taxes that Deborah talked about. So the bottom line is this means there's more exposure to federal income taxes for companies, and this in turn could make some of those there's a section called Section 1042, which you can do a tax-free exchange, so to speak, although it's really tax-delayed exchange for stock and an ESOP, and it may make that more attractive, and that allows for a huge deferral of the federal taxation on the gains from the sale of stock to an ESOP. The corporate tax rate reduces from 35% to 21%, and the expected result of that is to increase the appraised value of stock of private companies, and that's going to increase the repurchase obligations that companies will have for ESOPs, presumably. Presumably, corporations will have more cash on hand to actually repurchase stock from the ESOP when employees terminate or retire, but that will have an impact on ESOP repurchase obligations. The 20% deduction on the pass-through income that Deborah just gave us an example about could have a pretty big impact for S corporations, because a lot of times a less than 100% owned S corporation will make a distribution in the amount of the tax that is owed by the people who are outside of the ESOP. And then the ESOP gets the same amount of distribution. So since the tax obligation is going to be lower, the distributions to the ESOP will probably be lower as well.
Wow, that was like drinking from a fire hose, ladies. One of the things that I want to make very clear to our audience is that there is so much information in this tax bill, and the impact is so widespread. We do encourage you, if you have questions about how the tax bill impacts your business, you as a plan sponsor, you as a fiduciary, that you do reach out to our firm. You can reach our firm directly at 678-439-6236. You can also email me. I'm the firm manager, David Hall, at dhall@hallbenefitslaw.com. And as I suspected, we do have a number of questions, and I wanted to go ahead and get started on those. And the first question we have looks like it's probably most appropriate for Deborah. And the question is, regarding the QBI deduction, what happens if the business has a loss?
Well, the QBI deduction only applies if the business has income. So if there's a loss, the loss is going to be carried over in the following year to determine the income of the business. So for example, if the business has a loss in year one and has income in year two, then the loss in year one is going to be carried over to reduce the income in year two and therefore reduce the QBI reduction, the QBI deduction in year two.
Okay, great. And then I had another question. It looks like someone was asking, how will I get a copy of the slides? Great question. We will be emailing these to anyone who registered for the webinar. We will be posting the recording of the webinar onto LinkedIn and our other social media. And if that fails you, you can always, again, call the firm at 678-439-6236. And Deborah, we actually have a follow-up question regarding QBI. It looks like that's a hot topic. What type of planning opportunities should businesses be considering to maximize the benefits of the QBI deduction?
Taxpayers may want to evaluate whether a conversion would be beneficial. For example, an LLC may consider converting to an S corporation so the business owner can receive wages from the S corp for purposes of satisfying the wage limit component of the QBI deduction. However, usually the goal when dealing with S corporations is to minimize the owner's corporation in an S corp to the extent that it's reasonable to save on payroll taxes. So you're going to kind of have to balance the goal of saving on payroll taxes and trying to maximize your QBI deduction. Another thought is that some of these businesses that are providing specified services may think about trying to restructure their businesses in an effort to separate these non-specified services from the specified services to try to take advantage of the QBI deduction. However, you just really need to carefully analyze your own particular situation in order to determine, what steps that you need to take in order to maximize the ability of your use of the QBI deduction.
Okay, great. Thank you, Deborah. In the interest of time, we're not going to take any more questions, but I do, again, want to encourage you to reach out to our firm. And if you look at the current slide, you will see a breakdown of some of the things that I mentioned earlier. And our commitment is to excellence when we work with every client. We do the following work with excellence: employee stock ownership plans, ESOPs, employee benefits and mergers and acquisitions, executive compensation, health and welfare benefits, healthcare reform, retirement plans, and tax controversy and tax planning. We are focused on proactive legal compliance, which is one of the reasons our attorneys took the time to go through this new bill and to speak to you about how it may impact you and your business. So if you need counsel on proper reporting and disclosure notices, be proactive and contact Hall Benefits Law. If you need a review of your benefit plan administrative services agreements, be proactive and contact Hall Benefits Law. Counsel on cost-efficient, effective plan design alternatives, that is a specialty. Contact Hall Benefits Law. Be proactive and address ERISA legal compliance issues before they become costly legal compliance errors. We are on social media. You can follow us on Facebook, Twitter, LinkedIn, and YouTube. Our Twitter handle is @HallBenefitsLaw. And if you're not already signed up for our monthly HR alerts, which includes details of upcoming speaking engagements, please visit our website at www.hallbenefitslaw.com. And again, there is our phone number. I'll continue sharing our screen with you. And we very much appreciate your taking this time out of your day. We know your time is valuable. Please let us know how we can help.